Hello everyone and welcome to Compliance by Design. I'm your host Laurence Baker. Now, NDAs might not be the sexiest topic, but with the rise of AI, in this episode I wanted to dig into the impact it's having on contracts and how asset managers are reacting. We've seen a huge compression in deal timelines. What used to take 2 or 3 weeks from origination to being in the data room often now happens in under a week. In that world, speed isn't just a competitive advantage, it's essential to being in the deal at all. But what's interesting is that speed doesn't just test lawyers and deal teams. It tests how firms manage contracts as an operating function. When timelines compress, any lack of clarity around escalation or preferred positions gets exposed very quickly. Now, on top of that, we also have all these new AI tools. Just this month, we've seen Anthropic announce Claude for Legal, and these add their own security headaches in their own rights in terms of how teams, vendors, and the whole ecosystem use it, and more importantly, how clients and firms can protect their data. So to unpack what that means for the private markets and how both AI and legal complexity are reshaping the landscape, I'm joined fresh off the plane from Denver by our Managing Director of Contracts, Walt Nichols, and in London by Chrys Marincich, our Legal Director for EMEA. Welcome, both of you. Thanks for joining me.
Thank you, Laurence.
Yeah, thanks for having us.
So let's start with the obvious shift. Deal timelines compressing. The phrase time is money has never been more true, though in this case, time means no money. So, Walt, I wanted to start with you about what's driving that acceleration and what are you seeing about how it changes how contracts are managed day to day?
Yeah, I think what we're seeing is there are both macroeconomic and microeconomic factors that are in play. Deals are becoming more global, so bidders from around the world are looking at individual deals. That means getting into a deal is more competitive than it has been previously. Funding is also a lot easier than it has been historically to obtain. And so you have a lot of bidders trying to get in to look at the same asset, to be competitive and buy the same asset. And so they need to find a way to have a competitive advantage, to get into a process sooner. So when you say time is money, absolutely that's true. If you don't get into the deal room faster than your competition, you're losing the opportunity potentially.
And I think that's exactly right. And Chrys, I wanted to chat to you then about how that plays out in practice. Like, how do you maintain, when you've got these accelerated timelines, people are pushing forward, they want to get the deal room now. Like, how do you maintain the quality and consistency when that pressure is on?
Yes, for us, it's really about balancing responsiveness with preciseness. Our teams are trained to be genuinely commercial, so they focus really on the points that could really have a legal or commercial impact on the organization, rather on getting stuck on the nice-to-haves. So that means that at the outset, we talk to our clients and we agree on the parameters, so we're very clear on what really matters to them versus those points that they can be more pragmatic about. And we find a lot in the negotiation that some counterparties really focus internally. They have very rigid internal legal guidelines, even though where maybe the commercial reality of the situation doesn't call for it. And that can really slow down negotiations and can be quite frustrating. So our playbooks are actually just that, guidelines, not rules. And our teams are trained to always keep that commercial approach in mind when reviewing a document. And then, to add to that, it's just that I think that's why we also are using AI to manage some of the workflow. So it's been really key to help us manage the high volume, documents and the workflow with it, to find precedent more quickly, and basically just help us reduce noise, so human attention can be focused on where they can truly add value. Yeah,
I think it's a natural movement, and we're obviously talking about AI as part of this. The new capabilities that gives us in order to compress those timelines and focus on the high value work is really interesting. But one of the conversations we've had in the past, and I think is really interesting, is it's not just how firms are using AI to accelerate some of this stuff. We're now seeing them creep into the clauses themselves and the NDAs we negotiate. And from some of the conversations we've had, it's like some of them maybe aren't as commercial as they should be, etc. So How are we seeing that progression? What are we seeing there?
Yeah, that's a very interesting one because we have clients calling us almost every week about this topic. At the beginning, the clauses were frankly unworkable. They were very broad and they were to the effect of you shall not use any AI when handling confidential information.
Yeah.
Now, the problem is that almost every professional tool used nowadays incorporates some sort of form of AI, from email to document management to grammar and productivity tools, which would make those clauses really unworkable for the client. Where the market has been moving now, and what we advise our clients, is to do a more targeted approach. So we will tweak the clauses to say something like, you shall not use generative AI, to, the effect that the confidential information will become publicly available, or used to be train public LLMs, right? Which actually gets at the concern that most parties have. And often counterparties respond very well to that tweak because it addresses their concern.
Yeah, interesting. And what I wanted to, there's two bits there that I want to get your take on from a kind of America's perspective. The first is on the commercial side of things. Are you seeing, with the clients you work with, the same push to actually be more commercial? Is there resistance? And then the second part to that is, how is the kind of the US clients' take on that kind of Gen AI?
Yeah. I mean, it depends on the client, right? Each client and their respective attorneys might handle things differently, right? They have different preferred approaches. But I echo Chrys's sentiment that the kind of overarching sentiment initially was, thou shalt not use AI, right? It was a fear of anything
the unknown.
It's a fear of the unknown, right? And trying to manage the process rather than the outcome. And so I think what Chrys was getting at, and we're seeing the same thing in the Americas, is that if you actually ask a counterparty, what do you really care about? What are you concerned about? Is it really, which it usually comes down to, that you don't want your information being available for search or to be out in the public domain, right?
Yeah.
And we see that on a regular basis. And so then we couple that now with our client, where we're asking the exact opposite. How do you actually use the data that you're receiving? Is it to do some sort of a competitive internal analysis? Really, that you would be doing the same analysis, it's just you have a different tool and everything's internal. There are fences, parameters around it. In that case, we can probably find a pretty easy solution that bridges the gap between the counterparty's desire to protect and our client's desire to use that data strategically.
Yeah, I think that's very interesting, actually, because it does mean that we can really, that's the example language I gave you that we would generally advise, and we think it works for most clients. But the fact is that we really need to understand the technology of each client. Not each AI tool is just the same. As you know, our own AI is all proprietary, right? It's all internal. The information never goes anywhere, right?
Yeah.
As opposed to maybe some clients that they might want to use a tool that uses an LLM that's, somewhere else externally. And how do you make that work with the document? And you're still, in compliance with your obligations, right? So I think the first step is to understand what is the counterparty worried about, and then how does your client want to use AI to analyze that information, and then you can draft the legal language around it.
And how do you, and this is always something that's kind of interested me, as obviously you both work for a firm that was founded with AI at the core. A lot of lawyers won't have that exposure to different AIs and what they mean. So how much of your time do you spend helping other lawyers and our clients understand the ins and outs of AI versus?
I would say quite a lot. We are fortunate enough that, of course, we have our own chief technical officer, that this is their bread and butter. So I think we have to, right? We have a very good understanding of how the technology works, and that's why we can then advise accordingly. But that does mean then training both, our own attorneys and teams, and also then have those discussions with the clients. Because some clients actually, one of the GCs told me, I don't use AI in anything. There's no AI in my organization. And I was like, I can assure you that's probably not true.
Do you use Microsoft?
Yes. Do you use Outlook? Yes. Yeah. So it's just having those conversations, and some people are much more... It's a complicated topic. It's new, and that's why there's hyper focus on it, because people don't really understand it. In all industries, it's not just a legal industry issue. So I think as people understand the technology better, the language is going to settle, and it will become probably much more standard and far less contentious than it is today.
I think that one of our jobs as attorneys is to educate, right? Is to educate, number one, our own attorneys, right, within Avantia, but it's also educate the clients as to they say they have these concerns. What are the concerns really rooted in?
Yeah.
And then educating sometimes counterparties that there is such a thing as a middle ground where your needs are met, our needs are met. It's not necessarily a zero-sum game. So I think AI, because it's kind of that new frontier, AI provisions are just one of those where whether or not we want to do it every day, are going to be educating everyone on it. So,
yeah, and I think it is really interesting where the kind of conversations I've had, to your point, some of them like, no, we're not going to use AI on everything. It's going to take our jobs. And others are like, actually, obviously there's an angle here that it can be really useful. It can pick up some things, but yeah, most of these solutions are a black box where you don't actually know where the data's going, what it's doing, and how it's being used. So you do need to have these guardrails in place, and you do need to be careful about what you're putting in it.
Yeah.
I mean, I could keep talking about this all day because I do think it's really interesting how different industries and different people are approaching it. But one of the other things, actually, I want to flip this conversation slightly, because one of the things I have been talking to you both about for a while, and I love the term, is we're seeing NDAs. On the flip side, we've got AI that is making things faster and is meant to be helping and is going to be taking away and streamlining some of these tasks. But on the flip side, you've also got what seems to be NDAs are getting more complicated. They're getting longer. Whether or not that's good or not, we can discuss in a second. But I was at a dinner the other day, and a GC was talking to me about how she has been working on NDA for weeks, and it's just getting more and more complicated, unnecessarily so. And this is where one of the phrases you guys use, which I love, is the weaponisation of NDAs. So I want to talk about that and what you guys are seeing from that side. And if you could explain kind of what you mean by the weaponization, I'm going to start with you.
Yeah. I mean, when we say an NDA can be weaponized, an NDA can be used for the disclosing party to protect their information, right? This is a company that's looking to sell or obtain debt. And so they're disclosing their confidential information, their proprietary information, the information that's critical to their founders, essentially, and their executive team. And so they're using an NDA to limit what the recipient can do with that information. They want to limit the number of persons to whom that information is disclosed. They want to limit how that information can be used, who they can share it with, obviously, like their list of representatives. And then they also want to take, in some instances, extra steps to protect their company. So they put non-solicits in, they put non-circumvents if there's a broker, or if they're wanting to avoid someone going around the process, they want to bring buyers in. That's how it can be used as essentially a shield. And then buyers can be seen as using an NDA as a sword, right? You're using it to attack. You're using it to get the information that you can about a particular asset or company or target. And then you're trying to do your own analysis to put yourself in the most advantageous position to obtain that asset at the best price possible so you can provide that return to your investors that you need to provide. And so those sides are constantly kind of not in battle, but it's a back and forth.
You use sword and shield, so it's got to be a battle metaphor.
Yeah, it's you're constantly at war with each other, and that's okay. That's natural, but at the same time, it's how are we going to get our deal teams in quickly? Because both the seller and the buyer want that to happen. That they want that process to happen quickly. So becoming commercial or being commercial in your negotiations is absolutely critical to getting your buyers into the process, so you can have 20, 30 bids as opposed to one or two. And then from a seller's or from a buyer's perspective, you want to get in there as quickly as possible, so yours is the best bid possible because you've had the most time with the data.
How does that? I mean, you mentioned it there in your answer earlier about trying to be more commercial when we get to these negotiations. How does that play out? Like if you're up against someone that is, I can't remember if it was a sword or a shield, but someone's got some weaponry, and they're like, right, this is what we want to stick to. maybe they are making things overly complicated? Like, how do you manage that both from if it's our client or the counterparty?
Yeah, I mean, of course, we have agreed approaches for these clauses in advance with the client, but they're always still dependent, and you can't really negotiate them in a vacuum, right? So you have those processes that Walt was describing, where it will be common to see, let's say, an anti-exclusivity clause or non-consortium. It's almost expected, right? And so you could start the negotiation by saying, are you requiring every bidder, and has everyone accepted this? Like you could put like a most favored nation clause to ensure that you're not being disadvantaged against another bidder, which a lot of clients care about.
Yeah.
So if you understand the context and the process, then you can provide that information to your client, and that will inform how you negotiate the clause, and to ensure that it's still workable for the buyer, right, the potential buyer at the end of the day. You then have the other types of NDAs where a counterparty may use a template that was used in a different context. It was never intended for the purposes being used. And then that's why it's not commercially feasible what they're asking about. And at that point, you definitely need to talk to the counterparty and see what is it that you're trying to seek, because it doesn't work in this context. And you'll be surprised a lot of the times, actually, after we explain why it doesn't work, why the client might need that removed or amended, they're like, okay, yes, you are right. I remember, I think I had, it was last year, a clause that said, you shall not contact, your employees shall never contact our employees, period, in no context for 2 years. And we're like, okay, I'm going to give you a very extreme example, but let's say that my client has an employee that works for them, right? And then is married to your employee. Are you saying they cannot contact each other for 2 years? Surely that's not the intention of the clause. I mean, that's an extreme example, but the point was to show why it didn't work from a legal perspective or actually a practical perspective. And after that, they relented and they were like, okay, you should not contact them about this transaction specifically, which is what the actual issue was at the end of the day. So,
but some of these blanket clauses where they're like, right, we're just going to start at the worst possible case or the most risk-adverse scenario.
Like the same way we were saying about AI, you shall not use AI. Period. Yeah.
And I mean, we see it in virtually every deal that there are some NDAs where a counterparty will throw every single possible restriction. If we're on the buy side, we'll see every possible restriction. You won't solicit employees. You won't, right? We've walked through some of those already. And at the end of the day, you say, well, we're talking about a real estate deal. This is nothing, it's not a non-solicit that's relevant here. You might not want us to talk to the landlord, right? Or the loan holder, right? But a non-solicit is not applicable, right? And so in some instances, based on the situations or the type of deal, we can help, because we have the knowledge on the different industries, help eliminate some of those obstacles or the need to negotiate those provisions overall.
And is it just that the fact that, taking your real estate example there, the counterparties, our clients, they're only doing those types of deals, so therefore they've got a set template? Or I guess what I'm wondering is, why do they always start that case scenario rather than going, look, we know speed and time is of the essence. We want to go fast. We want to be commercial. We want to get this done. We want to get into the data room. Why not start at the best position rather than?
You mean the best position in terms of speed, as opposed to? It's a very good question, and it depends on the client's tolerance and risk. So I think what I would tell a client is that I think it's impossible to eliminate, risk completely, right?
Yeah.
So the points that you're trying to manage, okay, how can I protect my organization effectively while still allowing the business to move at speed, right? And that's where it's very important to understand, okay, what does the client really care about at the end of the day? Versus while maybe not ideal to agree to that, they can be more pragmatic because it doesn't really have a real organizational impact. Like the risk is so low, the likelihood of ever crystallizing into a real issue is just not important enough compared to the need of getting into the data room to evaluate that transaction. You risk, some of our clients need to get into the data room even the same day or within a few business days. And if you stall too much on the NDA, you might risk actually losing that process entirely. You might not be able to evaluate that transaction. So I think it's a conversation with the client and on focusing on those. I think the clauses you mentioned are actually key, and see if they're relevant. Maybe some of the clients don't. To give you an example, some of the clients maybe never enter into exclusivity clauses with any of their advisors, right? So if there's an anti-exclusivity clause in the NDA, there's no point on even trying to modify a little bit because it's not relevant to how they operate, right? While some people might automatically put some carve-outs or try to modify it a little bit. So I think it's very important, and sorry to repeat myself, but for each client to understand how they operate and then create a playbook based on that system and then negotiate with keeping in mind the context of each deal. Yeah.
I think one thing worth mentioning is that playbooks are good. Playbooks are great. However, they're only as good as the people that are involved in putting them together. Right? Because if you give us a set of rules, we can operate on those, fine. But a valuable playbook is one that's set up with the client's ultimate needs and requirements kind of in that list of either preferred, fallback, or don't go past this line provisions. And so those should be constantly evolving because the market is constantly evolving. Our clients' risks are constantly evolving. Their business lines will be changing, right, from where they are today to where they are 6 months, a year from now. And so we at Avantia see playbooks as living, breathing documents, and we train our teams to manage those and stay up to date on the current trends, on our clients' current needs based on where they are and where they see themselves, where they want to be in the market. And a playbook, instead of just becoming a set of rules, becomes, hey, this is how we're going to get your deal teams into the deal rooms faster. Yeah. And we found that our clients really appreciate that.
That was going to be actually one of the questions I was going to have was that as our market knowledge, obviously we're negotiating hundreds of thousands of NDAs. So how we play that market knowledge back into clients. It's okay, we've got a new client, they might be going into a new asset class. Yeah. They might start with a playbook and we're like, guys.
We've had instances of that where clients have said, hey, this is our playbook, and we've said, thank you. We might have some suggestions on how to improve that and improve your place in the market. Now, in some instances, the client might say, no, we want to hold firm on this. That's fine. Yeah. We'll still provide our coaching and try to add value, right, in making it so that they can fit in that particular market segment or niche market, whatever the case might be. But the fact that we see thousands and thousands and thousands of NDAs means that we do have our finger on the pulse of the market. We know what provisions are hot, which ones are, fought over very strenuously from month to month, year to year, and those change. It evolves. And so we do keep kind of up to date on that. We also know what litigation is ongoing, so we can adjust based on, hey, there's something specific to trade secrets if you don't protect it in a certain way, right? I'm not going to go into details on individual provisions, but we have to know that in order to serve our clients well. AI is just one example of something that we need to stay on top of. There are many, many others: data protection,
I was thinking the same.
Data regulations, et cetera.
That's a really interesting one, because one of the things I was also thinking about and having you both in the room to ask was, data protection is probably a key one, but seeing the cross-border differences and being able to have conversations, it's like, okay, you're now dealing with a Lux counterparty or in a different jurisdiction where actually there are different rules, different market trends, like managing that. Like, how do you have that conversation with the client? Being like, okay, well, yes, this is what you might have taken, the position you might have taken with a US-based transaction, but actually you're doing one in Europe that looks a bit different. There's different rules, there's different risks, there's different things we need to think about.
I mean, we know our markets really well, and of course, our teams work together across both the US and here. So I would say generally, NDAs don't vary too much. I mean, I don't know. You have Australia, where for some reason the NDAs are like 30 pages, right? But there are maybe certain conventions or ways I think people like to agree in certain jurisdictions, and we're very familiar to what those are. And maybe like how they will handle indemnities in certainly, the civil law countries versus someone like the UK, the US, where you would not agree to those, right? So again, going back to the guidelines is something that we know very well how they change in each jurisdiction, the very few points. And then we tweak those so they're very clear. Okay, so if you're dealing with a UK law governance, how you will do it. If you're dealing with American NDA, you will do it this way. But you will be surprised to know that I would say the difference are not. It's more a difference of style, really, on how to negotiate as opposed to the substance of the document. I don't know if you disagree.
No, I agree. I do think in some jurisdictions there are some substantive differences, but probably worth mentioning that we've built out and continue to build out our attorney base globally. So for those jurisdictions, we have competent attorneys that are able to manage that and lend that, give us that advice, give our clients that advice.
So I mean, I think that's really interesting. You mentioned there that our kind of growing any base and the market knowledge that we've got across all of this. I think it'd be good to talk about like how our lawyers, our attorneys, tap into that knowledge. Obviously, we have Ava, which is our internal tech, but how does that support? So if you're having a conversation with a counterparty and you're like, look, this isn't market or this is a not position, like how do you approach that with the data we've got to back that up?
Yeah, I mean, we have Ava, our internal AI system. Obviously, all information put into that system, we have walls in place, so the information is not being shared across clients, it's not being shared publicly. But our attorneys are able to leverage Ava in order to expedite our process. It helps with workflow management. It helps search for precedent. Obviously, if you're able to find precedent with the counterparty, you can eliminate the negotiation, getting your client's deal team into the deal room almost immediately, pretty quickly in most instances. We use Ava in order to help put our initial red line together. And then our attorneys, as an additional tool, our attorneys have Ava, and it's powered by AI obviously, to provide notices to our attorneys of, hey, this is due in 3 hours, or this has been sitting with a counterparty for a day. And then we have reminders and template emails that we can utilize all through our proprietary AI system.
And it also, so a lot of our clients are very interested in know basically their own data. And so with Ava, we can also get that information. So we know how long it takes us on average to agree a document, how long the other party has taken in respond, how many documents we've processed, with whom, what type of documents. So it helps us gather all of that information, and we have it available for clients when they want to see it.
And does that, I guess, going back to our initial point about taking more pragmatic approach, being more commercial and accelerating the time to signing, by going back to, say you get a new playbook and you're like, look, some of these things aren't realistic, or actually this is a position that we shouldn't be taking because it doesn't fit market or it's not commercial. Going back to them saying, it's not just us saying this. Actually, we've got all the evidence here to prove that's the case. Is that an easier conversation, or?
Yeah, I think it is, absolutely, because we can say, hey, we can take this position, but we have seen over the years and over the thousands and thousands of documents that this is going to add 1 to 1.5 turns per document. And we can estimate the average additional time frame. We're happy to do it, but are your deal teams happy with that additional?
If you want to be in there before everyone else.
Right. So that's a decision that they have to make strategically. And for some clients, they're okay not making that change. Others are saying, oh, no, absolutely. Give us that. And what else can we do to streamline the process? Chrys, what are your thoughts?
No, I agree. I think the fact that you mentioned we have the present search tool, it makes it very easy to see what is been agreed before. So we can say with confidence, in the past 100 documents, I have never seen that clause. Now, whether the other counterparty agrees or not, I mean, that's a different matter. But we're very confident on the data we gather with our AI tool.
Yeah, I think this is where for me, like when we talk about AI, a lot of, we kind of mentioned it earlier, but a lot of this stuff is quite embryonic. It's quite new. It's some of it isn't quite there, I think, a lot of times, and that's just not on the legal side. We're seeing that across industries. I think there's cases where it's more around the guardrails you have in place, how you're using it in the data, how you're using it to help influence the decisions you're making, rather than it being a wholesale job lot outsource. And I think for us, obviously, that's only improving and getting better. And I think across the industry, as we build this playbooks, we build this data, it is really going to help. But at the end of the day, you still need someone talking to the counterparty, someone talking to the client to explain why?
Yeah. I mean, our clients rely on us because we have phenomenal attorneys. We have phenomenal attorneys that know commercial NDAs, that know event agreements, that know engagement letters, NRLs, SAS and PASS agreements, right? So we have all of these different competencies and skill sets that our attorneys are experts in. They focus exclusively on. And that lends tremendous credibility when we go into a room to a client and say, we understand what you're talking about. We understand the pain that you're having internally in this department or that department. Let us help you. So that's what we're seeing pretty consistently, I would say, across the globe.
Yeah, and because we work so closely with the tech team, so the whole point of AI was to just help us eliminate those processes where it could be automatized, so make it easier for the team so they can actually focus most of their time on the negotiation and talking to the other party. And we're lucky enough that because we have both lawyers and the tech team right under one roof, we are in constant communication with the tech team and tell them this is what we need as lawyers, this is what will be helpful. And so it's definitely a process that is enabled by AI, but it is driven by people at the end of the day.
Yeah, it's having that the lawyer in the loop. Attorney in the loop. I'll get that right one day.
Yeah, attorney in the
Every
loop.
time I say lawyer, you look at me.
But at the same time, it's also attorneys helping to develop and drive our product, to drive our AI. And that's critical because it's not just a tech solution that's being rolled out to attorneys. It's attorneys helping to roll out the solution for attorneys. And we know how it works.
Yeah. I think that is the thing. This is slightly off topic, but watching you guys work alongside the tech team means that we can ship the updates much faster. Actually, what we're getting works. It's not a solution that's being bolted on. It's not something that you've got to learn. It's a actionable tool that actually helps day to day. It's a shameless plug for Ava there, but it's fine. I'm in marketing, so it works.
Yeah, we love that part of our job.
Now, this was a really interesting conversation. I think for me, it's at least what I'm seeing and from what I've seen over the last couple of years, I mentioned at the top that kind of need for speed, trademark, don't sue me, is becoming more and more clear. And it is becoming that competitive advantage where if you're not in the data room pretty much instantly, someone else will get there first and you're going to potentially lose out on the bid or you're going to spend time looking at something that you could have written off and spend your time looking at the next thing. So I do see the deal timelines are only going to continue compressing. And actually, this is why hopefully we'll see more commercial terms and more pragmatic approaches, but it's only going one way. I think it's going to be really interesting to see what the next phase of this looks like, especially with everything going on. But maybe we can come back in 6 months' time and review what's changed.
Yeah, we love that. We'll bring you the data.
Yeah, that would be awesome.
We're going to help drive those changes.
Yeah. Yes, I love that. Well, that's everything we had time for today, but Walt, thank you for flying over just to
Thanks for having
join
me.
us. Chrys, thank you so much for joining.
Thank you.
Thank you everyone for listening.